ability of movable and immovable properties when it comes to reselling. For example, land in Dubai, which law will be applicable if at all the deceased had land in Dubai? And also for movables, which law will be applicable? I think I didn't get you correctly on that part.
Stop playing. We talked that was like the entire class. That is like the entire class. What did we say? Which law is applicable in that respect? We read the act and that is the entire class we had. So if you say that you didn't get
No, I'm saying I partly got you to an extent of where.
What did you get? Let's start there.
For example, in the law of the land is that every country shall have exclusive jurisdiction.
So once you know that and you're asking me the land in Dubai, which law will be applicable? Are you asking
I'm
me?
not asking you that. On movables rather.
What did we say about movable? That's what I'm asking. You said there's movable, the law of the land. What about immovable? I mean the movables. What did we say? That is what I'm asking you.
That is lacking in my.
What did we say? What did you get? Because we need to start from what you got and then see what else was missing so that we can cover it.
I got everything correctly, save for the movables now.
So what law is applicable to the movables?
That's what I'm asking now.
All right. Pick someone. Pick someone from the team. Pick somebody.
Nyangao Skita.
Skita Nyangao.
Yeah, today is it Miena? Today's a bad day to pick me up. Politely ask someone else to do that kindly.
Let's answer the question.
But Malimu, I don't know, to be honest. I really, if I knew, I would have answered. I have no problem answering something I know.
Then just say, I don't know. What do you mean is a bad day?
Rewind. I do not know the answer. Kindly pick somebody else.
Ngeno, pick somebody else.
Maybe in the interest of time, I can pick you.
There's no interest of time. Pick somebody else.
We have Evans Mwangi.
Evans Mwangi.
Thank you. I raised my hand so that I can be informed. I've just joined. What is the question?
Okay. Ngeno, pick somebody else.
I thought maybe you'll give me a justice by explaining the question so that I may try to answer it.
No, justice is not served here. Ngeno.
I think if just picking it from if at all the law of the land applies to immovables, then automatically the law of for immovables it's the law of the land. Then the opposite is true.
There's nothing like opposite being true. What you're saying is incorrect and untrue. Pick someone else.
Tianga Jennifer.
Jennifer, proceed.
For movable property, the law that would be applicable would be the law of the foreign jurisdiction, and you would need to get a grant if, for example,
Pick somebody else.
okay.
Hizo ndo mimi nafunzanga hizo. Hey guys. Younger, send somebody else. Younger, you're wasting your time.
You said I pick someone?
Yes.
Oh, Alingo Penina.
Nina, proceed quickly.
The domicile of the apologies for the noise. I hope you can hear me. It would be the domicile of the deceased person. Like have I answered?
You've not answered that question. Can you answer that question in full?
Okay, I can say it this way. If the deceased person his domicile was maybe in Kenya, where he used to live and reside, and then let's say he held money in Uganda. So when the grant is being taken in Kenya, that grant will be taken to Uganda to claim that money. So it will be the domicile.
Leave alone. It's not about where the grant is being taken. That is a different story. Where you take the grant is a different story. The story is which law will be applicable to the immovable properties that you have. I'm sorry, to the movable properties like money in the bank.
Okay, the domicile of where the deceased person resides. That is what I can say.
What is domicile? Quickly. Nina, stop wasting time. Can you proceed and speak? What is domicile? I'm assuming you can't hear me.
Okay, Mwalimu. It is the domicile. I can say that it is the country that a person treats it as a permanent home, like the permanent home of a person or the permanent home of a deceased person.
Where did you read that?
Not treating, resides.
Mute your microphone, please. Nina, where did you read that? Hiyo ulisoma wapi? Nani amekufunza hiyo? What is domicile?
Apologies. Where the again, apologies for the noise. Where a person resides, I can say that it's the domicile of that person.
All right, thank you. So guys, it is important for you to understand that. It is very, very important for you to understand how those factors come to play. Very, very important, extremely very important. So let me explain the Ngeno's question so that we are on the same page. This is something we did in the last class, guys. So Ngeno, you didn't even take time to go through the recording. Even at one point, you were in class, but you didn't go through the recording. You knew very well you didn't understand it, but you waited and say, okay. Okay. So please get the recording and try and look at the recording. Okay, so let's talk about that specific idea. And I'm going to start from section. Let me just go there right now. So I'm going to start from section 4 of the Law of Succession Act. That is where we start from. I'm going to project my screen. That is the Law of Succession Act. So it says that except as otherwise expressly provided for in this act or by any other written law, succession to immovable property in Kenya of a deceased person shall be regulated by the law of Kenya, whatever the domicile of that person at the time of his death. That's one. Two, succession to the movable property of a deceased person shall be regulated by the law of the country of the domicile of that person at the time of the death of that person. Okay, then that simply means that if you die and you leave behind two aspects of properties. Number one is a movable property. Number two is immovable property. The succession of your movable property, which is a car, money in the bank, shares somewhere, will be done, okay, will be done according to the law of your domicile. Okay, now the succession of the immovable properties, the land, the buildings that you leave behind, shall be done in accordance to the law of the country where that property is. So if that land is in Kenya, the laws of Kenya will govern the succession of that specific immovable property. Now, the second thing you need to understand, which I already explained, is that succession of immovable or movable property doesn't mean the grant. It doesn't mean we go and take the grant where the property is. If you died and you are domiciled in South Africa and you had money in South Africa, of course you know that the law applicable will be the South African law because that is where you are domiciled and you have a movable property. Are we together? Now, in that respect, it doesn't mean we go and take the grant in South Africa. No. So long as you're a citizen of Kenya, the grant will be taken in Kenya. But for us to access the property in South Africa, we have to go and reseal it. So we take the grant in your country of citizenship. For us to access any property that is outside the country of citizenship, we have to go and reseal it. Okay, but when now it comes to succession, now that is the distribution of that property, we are going to ask ourselves very clear questions. Number one, where were you domiciled? You are domiciled in South Africa. Then the succession of your money that was left in South Africa will be according to the rules of South Africa. So that if the South African law says that female beneficiaries are not supposed to inherit more than a quarter of any money that is left behind, then we shall not give your female beneficiaries more than a quarter of the money you left in South Africa. The other example would be you are a Kenyan, you're domiciled in Dubai, where you work and stay. You die and you leave money in the bank in Dubai, or you leave a car in Dubai. What are we going to do? Take the grant in Kenya and then go to Dubai and reseal it. Why do we reseal? We reseal just for purposes of access. Okay, that is resealing. So once we reseal it, then we can access the money and then we can access the car. Now, the Dubai law will come into play when we start now distributing succession. When we start distributing now the estate, whereby we'll be saying, according to Dubai law, female or male beneficiaries are not supposed to inherit this specific property. So if that is a law in Dubai, then that is what we are going to be doing here. So we will not give you a car if it is an offense in Dubai for you to have that car. Okay. If it is if it is the law in Dubai that a quarter of what you have, a quarter of everything that you have as a deceased person shall be donated upon your death, shall be donated to maybe charity, then when distributing your estate, we shall, so the movable assets that you left in Dubai, we shall take a quarter of that and take to charity, because the succession simply means now, succession doesn't mean grant. It simply means this person takes this, takes this, takes this. Are you together? So when we say the succession of movable property shall be regulated by the law of domicile, we are not saying you go to that law of domicile and take the grant there. No, the grant is taken where you are a citizen. We take the grant and then we will access the property. Once we access the property, then we ask ourselves, it is movable, the law where the property is. It is it is movable. That is domicile. Okay. So make sure you understand that. So what is domicile? Domicile is your usual place of residence. You know. You know. Are we together? You're the one I'm waiting. This was your question.
Thank you so much, Mwalimu. It's now very clear.
Okay. So that is Songeno, Skita, and the rest who might have had that question disturbing them. That is already explained. So please, guys, let us go and I'll take another question. I'll take two questions regarding what we have discussed before that is not making sense for you. And then we shall proceed and do other things. So any person that is having a question on something that we have discussed before, or a general question in terms of succession, and then we can answer it as we get into our discussion for today, which I really believe and hope will be our last class so that we can start doing the past papers. Evans?
Sorry, I put my hand down.
All right, Tua John. Mute. Nabakwe, please. Mute. Tua John.
Okay, Mwalimu, if you'd kindly explain now the process of citation. I know what citation is, but now the procedure is what I did not understand. Citation is whereby someone who is supposed to apply for a grant and has not done so is cited by another person to take out the grant.
Okay.
Now the
to take
process.
to take out the grant or what?
Or to renounce.
Renounce what? Can you give complete sentences, please?
Or to renounce, to state that they are not going to proceed taking out the grant.
And what if they renounce? What happens?
If they renounce, another person who is now next in the line may take out the grant.
All right. So as per usual. So pick somebody to explain to us the process of citation.
I would pick Penina.
Penina.
Alingo.
Alingo, please.
Okay. I'll try. Okay. Now,
we have, according to the law of succession, if the person died, let's say, for example, if a person died testate, then of course in the will it has provided the beneficiaries or who are to inherit. Huh?
Just somebody mute your microphone, please. Somebody speaking in the background, please mute your microphone. Thank you. Yes, Penina. Sorry, John. No, John. Penina, proceed.
Okay, so when one of the if it is it has been provided for in the will, the will if it has provided for who are supposed to be the executor when it comes to now the estate of that deceased person, the named executor there will apply for this letter of grant of probate. But where where the will is subjected to intestacy, where a person has died without a will, we will be guided by the section 29 of the Law of
Penina,
Succession Act, which we have. Yes.
what are you
Yes,
explaining?
Mwalimu.
What is the process of citation?
Okay, the process of citation is when it comes to the order of priority of the people to take out the grant, the grant, and let's say, for example, if we have the wife and the wife has not taken out the grant, then the other beneficiaries who are interested in the estate will cite the wife. Citation is a citation for acceptance or refusal. So when this person who is cited will accept, then he or she will make an application. Will make an application for letters of.
How are they
Yes.
cited? You are saying if they accept what, please? How are they cited?
You make an application in the prescribed form, Mwalimu.
Who makes that application?
The person who is now citing a beneficiary to now the estate and who is not, for example, in the past.
Must they be a beneficiary? Must they be a
I
beneficiary?
believe so, yes. Yes, Mwalimu, because now when it comes to law of intestacy, the estate will now vest on the immediate family of the deceased person.
What if it is not intestacy?
Then any person who has been provided for in the will.
Must they be provided for in leave alone the provision? Can a creditor cite?
Yes, he can, because he has an interest.
Is a creditor a beneficiary?
A creditor is not a beneficiary.
So must they be beneficiaries?
No, I've gotten that. It's not about for the beneficiaries to cite.
Okay, proceed.
So you'll make an application in the prescribed form to cite this person. The person who is supposed to take out the grant, because now, Mwalimu, you said, I believe in one of your classes, you said there's a list of people or the priority at the rank of priority to take out this grant. We have a spouse, children, other beneficiaries, a public trustee, or creditors. Those are now being provided for by the law of succession. So among these people can cite.
What is the procedure? Hey, you're not answering the question. You're just saying beneficiaries, we people who can cite. Tell me the process of citing. The question is, if you want to cite, what do you do? Step 1, step 2, step 3, step 4. Don't go into will, executor, and all that.
You make an application in the prescribed form.
Who makes the application in the prescribed form? Who is you?
A person who is interested in the estate of the deceased person. To cite.
Who cite? Who can cite? Who can cite? Let's start there. Who can cite? Who can cite?
Any
person?
A person who is interested. Any person who is interested in the estate of the deceased person, Mwalimu.
All right.
I don't know if that is the.
That is fine. But now when you cite, you are called who?
As Saito.
Okay. So start there now. What will happen? The procedure now.
Okay. Now a Saito will make an application to court in the prescribed form to cite a person who will be now the citee to either to accept or to refuse to now to take letters or to take the grant of letters of administration. So if this person, if the citee,
must it be letters of administration?
It can be grant of probate, Mwalimu.
Then
or
use
it
a
can
general
be
word. Use a general term. Decide them to do
a
what?
grant. To take out the grant. So if this person accepts, then he or she, the citee will now take up the process of obtaining the grant. But if he refuses, the next order of priority will now continue to take out the grant.
That is not what happens.
Maybe.
Take somebody else to continue. You've rightfully noted that the citee, which in this person is the person that is citing, who is any person that is interested in the estate of the deceased person, will make an application to court in the prescribed form. Okay, citing the citee, that is the person who is supposed to take the grant. Now, in testacy, this person is the executor. In testacy, this person is the person that is in priority. Okay, the person that is in priority.
Yeah.
Okay, that is a requirement. The person that is in priority is the one that is going to cite, who is going to be cited by any person that is interested in the estate of the deceased person. Okay, now once they make the application in the prescribed form, but before they do that, because let's discuss this. What is the requirement for you to be a citee? Nobody can just wake up and cite. For you to be a citee, you must be somebody that is able to get the grant. Any person that has the ability to apply for the grant but hasn't applied for the grant. Okay, because why do we say that for you to apply for citation, you must be somebody who is entitled to get, who is capable of having the grant? The reason is very simple. When you look at the final process, when you look at the end result of citation, it is that if you are successful in your citation, then if this person refuses, the citee refuses to take out the grant, then the grant will be given to you as the citee. So for it to happen, you must be somebody who can, okay, who can get the job, okay? Same way we could say that if you are in a school and you want to cite the principal, for instance, you must be somebody who can be the principal. If the principal is successfully cited, then you must be somebody who can be the principal. So a student cannot cite a principal, because at the end of the day, a student cannot become a principal in that instance. A deputy may become a principal. So the same way, for you to cite somebody, you must be somebody who can be given a grant. So who can be given a grant? Under section 66, the first person is, of course, the executors of the will. But in terms of where there are no executors, who then can get the grant? Under section 66, we have the spouse, we have the beneficiaries of that estate, we have the public trustee, and we have we have the creditor. They could apply to get a grant. Are we together? So that is the qualification. For you to apply, you must meet the qualification, which is you are somebody who can be able to be given a grant to that estate. Suppose the citee is not willing, or suppose the citee has renounced their right to apply for the grant. Are you together? So what is the process? Make an application in the requisite form or in the prescribed form. Okay. Number two, once the registrar, the registrar has received your application for citation, the registrar shall notify the citee that they have been cited, and therefore they should either make a decision to take out the grant or to renounce their right to take it. Okay. Then the citee will be required to enter appearance and file their response, whether they will be proceeding or they will be intending to apply for that grant, or they are renouncing their right to apply for the grant. Okay. Now, once they renounce their right, then the registrar will notify the citee to put in their application for grant, and then the court will proceed and give the citee the grant. Are you together? So that is the process. So make an application in the prescribed form. Number two, once you make that application, of course, the citee is notified. Then the citee will either enter appearance and file their response, and also make an application for grant if they want to make an application for grant. And then after that, then if they refuse or if they renounce their right, if they don't respond or they renounce their right, then the grant shall be, the registrar shall notify the citee to put in their application or their petition for grant, and the court shall proceed and give the citee the grant. That is the process of citation. That question was for Thua Joan. Are you answered?
Yes, sufficiently, Mwalimu. Asante.
All right, last question. Skita.
In the event that the citee either denounces their right or does not enter an appearance, you've said that the court directs the citee to go ahead and make the application. My question is, now that we have the order of priority in how people in who should take out a grant, let's say you cited the surviving spouse, and they have either denounced their right. Do we now forgo the priority and actually give?
Yes.
Let me just start. Okay.
The priority does not matter at that moment. The priority doesn't matter at that moment. If the person in priority is not interested in applying, then they need to inform the person who is second in priority. Now, if all of them are not applying within the time provided, then the person that are cited will make an application. Okay. Now, even in this instance, we can have an instance where the person doing the citation is the person who is second in priority, the beneficiary. So the beneficiaries will cite their mother, and if their mother is not applying, they will apply. Okay. Or a stepbrother, okay, will, suppose a stepbrother also is a beneficiary to that estate and can get a grant in case there is no first and second immediate family. Now, in that instance, they will cite the people in priority. You can cite one person, or you can cite even two people, depending on who you want to cite. If they don't, then priority doesn't matter in that instance, because all these people, if they wanted, they could have made the application. But if they're not making it, let us give it to somebody else. I hope your question is answered.
Yes, thank you.
Anina, what is your question? That's the last question I'm taking.
Oh, first of all, Mwalimu, thank you. And my question is, let's say, for example, if we have been given a question where an administrator or an executor wishes to be removed from being an executor or an administrator for purposes of taking a grant, we take a limited grant for grant de bonis non-administratis.
Why?
So this person. Okay.
Your question is not clear. They want to be removed. At what point do they want to be removed?
Before now the grant is being issued by the court.
Okay, if the grant has not been issued, why are you taking the grant at Diboni? When do you take the Diboni grant, limited grant?
Oh, sorry. After the grant has been issued, Mwalimu, by the court, after now the process of obtaining the grant from the court, and then when this administrator has not yet completed distributing the estate to the relevant beneficiaries. Now, when this person wants to be removed as an administrator, what is the process now? Does he make an application to court to be removed from the grant, Mwalimu, or that is where I'm having an issue?
They first have to notify the court through an application, of course, to be removed. And the second thing, the court will revoke the grant given to them. And then the party, whoever is interested, will make an application for Diboni and an administrative, depending on how far they have gone. If they have not distributed anything, then a new grant will be issued to somebody else. So this one must first be revoked, because remember that one grant cannot be administered by different people. You can only administer a grant if that grant has your name. So notify the court will revoke the grant, and then a new person will be given the grant. Or even in some instances, you just make an application for revocation. You make an application for revocation of that grant, and one of the reasons is that grant has become useless or inoperative because you no longer want to administer it, and then it will be revoked, and then somebody else will. Once a grant has been revoked, the process will start afresh from the application stage. You apply for a new grant, the same way they applied for it. You apply for it. Are you together?
Yes, Mwalimu. Is it now the same if now the administrator is dead? We have to revoke that grant again, and make now an application for the bonus. Okay.
The grant, unless there's someone remain. If there were two, and one has died, we don't revoke the grant because there's still one remaining. But if it's one, we have to to revoke the grant. If you die, you have to revoke the grant and then give it to somebody else.
Okay. Thank you, Mwalimu.
So when you die at an instance where you had started distributing and you die, in that instance we revoke this one and then we issue a Diboni, that is the limited grant. But if you die before starting the process, then of course we will revoke the grant and then somebody else will have to apply for that grant afresh. That answers the question. So let's start with the discussion today. Joan, put your hand down. I'm not taking any further questions because of time. Please.
You require a yes or no, Mwalimu. So, in an instance whereby now the executor named in a will does not want to administrate the estate, we fall back now to section 66.
That is not a question
on
that
the priority
requires,
now.
That is not a question that requires yes or no. So I will answer that question later. It is not a question that requires yes or no, because I'll tell you no. What does no mean? Or yes, what does it mean? So please, let's go to the discussion today. All those questions will be answered after the class or towards the end of the class. Thank you very much. Now, let's come back to today, okay? Now, I want us to talk about the question to do with the personal representatives. Personal representatives. So who are the people that we call personal representative? Who are the people that we call a personal representative? Somebody tell me, who are the personal representatives? Who is a personal representative? Give me the two categories. Arias.
Mwalimu, have you called me?
No. Alice.
Have you called me too?
Yes. Proceed. What's the answer?
Yeah, personal representative are more of administrators.
What do you mean they're more of administrators? That is a wrong answer. Penina. What do you mean more of administrators?
I didn't
Penina,
even finish explaining.
you don't need to go further.
Personal
Jurisdiction.
representative are those who represent the estate of the deceased person.
Time has passed you. Time has passed you. Your first statement denied you jurisdiction. Tabitha Masesi.
Mwalimu, you called me.
Because your hand is up. When I call you, there's only one thing I want from you. If you put your hand up, then you need to answer the question if I call your name. Tabitha, your hand is no longer
They are the
up.
executors. Executors.
Alingo Masesi. Your statement is not complete. Who are these people we are calling administrators? I mean, not administrators, but personal representatives.
They are the executors of the estate.
That is not a complete statement. There's a reason why I'm saying that. There is not a complete statement. When do we have executors? Masesi.
When there is a when the deceased has appointed a representative.
Where?
In the will.
Can you give me complete statements? Those things are making me feel like I'm in Punjab. Can you give me a complete statement?
When the deceased person has appointed an executor in the will.
Okay, that is an executor. So what if he has not appointed?
An administrator.
So who are personal representatives?
They are administrators and executors of an estate of the deceased persons.
All right, that is exactly what I'm looking for. So these are people that are entrusted with the duty, okay, with the duty of administering the estate of the deceased person. So we have the executors. The executors are appointed under the will, okay? And then we have administrators. Where the will is not there or where the will has not appointed an executor, then we shall have an administrator, okay? Are we together until that point?
Yes, we are, Mwalimu.
Yes, we are.
All right. That is the first one. The second one is the powers of executors versus the powers of administrators. These people are not equal. They're not equal. They could be doing the same thing, but in the ordinary sense, they are not equal. So executors are appointed under the will. Okay? Executors are appointed under the will. Are we together? So that means they derive their powers from the will. Okay? They derive their powers from the will. That is very, very important. So anytime somebody has been appointed under the will, anytime somebody has been appointed under the will, then the moment the will becomes valid, the moment the will becomes valid, the moment the will has become valid, then that person's power will automatically kick on. Okay, so administrators will have to wait later. I mean, until a point where we have the grant. But executors of the will will get their power under the will. So the moment the deceased person dies, then the executor will already have the power even to distribute the estate. They are able to distribute the estate because they derive their power from the will. Okay. On the other hand, we have somebody called the administrators. Now, the administrators of an estate of the deceased person will have to get their power from the grant, and therefore they have to wait until they're appointed by the court. And how are they appointed? By being given the grant, by a grant being made in their name. Therefore, they are appointed in that instance. So their powers will come after the grant. executors after death, administrators after the grant. All right, somebody read for us what are the powers of personal representatives? 82.
Shall I read?
Yes.
Okay. Section 82, powers of personal representatives. Personal representatives shall, subject only to any limitation imposed by their grant, have the following powers. A, to enforce by suits or otherwise all causes of action which, by virtue of any law, survive the deceased or arising out of his death for his personal representative. B,
Yes,
to
just
sell.
okay.
Okay.
Just stop there. Let me explain. What that means, so that we are all on the same page, guys. We have the powers and we have the duties. Okay, we have the powers and we have the duties. Okay, the powers of administrators and executors, as well as the duties of administrators and executors. They are related. You just need to get a way of moving around it. Okay, so the power can become the duty, and the duty can become a power. Are we together? So that is clear. That is very much clear. That is very, very much clear. All right, so the first one is powers in relation to a suit. Powers in relation to a suit. Are we together? Powers in relation to a suit. What do I mean? Now, as a personal representative of the estate of the deceased person, you have certain powers relating to a suit that is brought against the estate of the deceased person. Okay, you have certain powers in relation to a suit that is brought against the estate of the deceased person. Are you together? So the first one, you can institute a suit. Personal representative can sue on behalf of the deceased person's estate. They can institute a suit. Are we together? That is the first one. They can come out and make a suit. In a plaint, normally you say person XYZ suing as a personal representative to the estate of the deceased person. Okay, so that is the first one. They can as well defend a suit. Defend a suit. They can defend a suit. So personal representatives will also have the power to defend a suit that is brought against the estate of the deceased person. The third one, they enforce a suit. Enforcement of a suit simply means that if a court order has been issued in favor of the deceased person's estate, they can go and enforce that order, maybe by a realization or execution of that decree. They have the power to enforce the suit. So that is the power in respect to a suit. Okay, so that simply means also as well that can become a duty. So you can say the duty to sue on behalf, the duty to defend, and the duty to enforce the suits. So both works, a duty and a power. Tuko sawa? The second one is the power in relation to the power to sell. Read for us the power to sell.
Okay. B, to sell or otherwise turn to accounts so far as seems necessary or desirable in the execution of their duties, all or any part of the assets vested in them as they think best.
Yes. Very, very important. Very, very important. Yes. Somebody's
Shall
asking a
I
question.
proceed?
No. Wait first. Somebody's asking something. Proceed. Okay, nobody's having a question. All right. Let us go and talk about the second one. So they have the power to sell. Okay, the power to sell. So the power to sell could also sometimes be a duty to sell. So they have the power to sell part of the estate of the deceased person if it is necessary, number one, to pay the expenses, the fees, the charges, taxes, and everything else. That will be the first instance. The second instance, they have a power to sell part of the estate which is perishable. So if there's any part of the estate that is perishable, they have the power to sell that. At the same time, they have a duty to sell and pay the expenses regarding the succession. For instance, if this person left behind just land and buildings, there's no money that was left. You have to sell part of that land so that you can even pay the lawyers. Okay, so that so that is the power to that is the power to sell, which can also become a duty to sell. Are we together?
Yes, Mwalimu.
All right. Let's proceed.
Okay. Provided that one, any purchase by them of any such assets shall be voidable at the instance of any other person interested in the asset so purchased, and no immovable property shall be sold before confirmation of the grant. Mwalimu, kindly scroll up.
So, provided, let's go to the proviso.
Okay, let me start again. Provided that one, any purchase by them of any such assets shall be voidable at the instance of any other person interested in the asset so purchased, and no immovable property shall be sold before confirmation of the grant. Shall I proceed to C, Mwalimu?
Yes, proceed to C. Go to C, yes.
Okay. Yes, to assent at any time after confirmation of the grant to the vesting of a specific legacy in the legatee thereof. D, to appropriate at any time after confirmation of the grant any of the assets vested in them in the actual condition or state of investment thereof at the time of appropriation, in or towards satisfaction of any legacy bequeathed by the deceased or any other interest or share in his estate, whether or not the subject of a continuing trust as to them may seem just and reasonable to them according to the respective rights of the persons interested in the estate of the deceased, and for the purpose to ascertain and fix with the assistance of a duly qualified valuer where necessary the value of the respective assets and liability of such estate, and to make any transfer which may be requisite for giving effect to such appropriation.
Thank you.
You're welcome.
Thank you. All right, so that simply talks about the question of selling, the rules regarding selling. So you just need to understand that they have the power to sell the estate of the deceased person at any time, at any instance, provided that that sale is required for purposes of either administration or payment of expenses and all that. Okay. Now there are certain powers also as well that we need to include. The other one is the power to collect. They have the power to collect an estate, the power to collect the estate. So once you get the grant, then it gives you the power to proceed and collect the estate of the deceased person, wherever that estate can be, will be. They have that power, so they can go out and collect and all and all and all and all. Okay, and then of course they can always act as an agent of the estate of the deceased person at any time when so required, depending on what the circumstance is. Okay, and then of course they have the power to distribute. That is the power of distribution. The power of distribution to the respective beneficiaries, and all and all and all. So those are the powers. So we'll see some of the duties that also can become powers. So when you get to duties, you'll find that some duties are actually also some power. So like I've said, you just turn it around. The power to sell, the duty to sell, if. Okay. All right. So any question on the question of powers? No question. All right, let's go and talk about now the duties. The duties. What are some of the duties that we have? Somebody read.
I can go ahead and read.
Mhm.
Okay. Duties of personal representatives. Personal representatives shall have the following duties. A, to provide and pay out of the estate of the deceased the expenses of a reasonable funeral for him. B, to get in all free property of the deceased, including debts owing to him and monies payable to his personal representatives by reason of his death. C, to pay out of the estate of the deceased all expenses of obtaining their grant of representation and all other reasonable expenses of administration, including estate duty, if any. D, to ascertain and pay out of the estate of the deceased all his debts. E, within 6 months from the date of grant, to produce to the court a full and accurate inventory of the assets and liabilities of the deceased and a full and accurate account of all dealings therewith up to the date. Can scroll up.
Yes. No, just leave it there. Let me explain.
Okay.
Let me explain that. So in as far as the power, I mean the duties, not the powers actually. The duties are concerned. I've said this can also become, they can also become powers if you just turn it around. So the first one is the duty to pay. So in terms of payment, there are a lot of payments that we can make. So out of the duty of paying, you can get a lot of powers or duties from that. So the first one is the duty to pay the expenses, the funeral expenses. The funeral expenses, that is a duty to pay. So you as the personal representatives, you know that the funeral will cost some money, and those expenses that are accruing as a result of a funeral, you'll have the duty to pay them. That is the first thing you are going to pay. Okay. The next thing you are going to pay is the debts. You have the duty to pay the debts of the deceased person. You have the duty to pay the debts of the deceased person. That is a duty to pay the debts. Okay. The next one is the duty to pay the expenses regarding the administration, the expenses of administration, such as let's say could be valuation, legal fees, court fees, and all that. All those are expenses relating to the administration or the execution of that specific will or grant. So all those expenses you pay. So you pay the funeral expenses, you pay the death of the deceased person, you pay the expenses relating to the administration. And then we have another a duty, that is the duty to collect. The duty to collect. We talked about this. Okay, the duty to collect. So what is this thing called the duty to collect? What are we collecting? Under B, the duty to get in all the free properties of the deceased person. So you have to collect all the properties forming the estate of the deceased person. Are we together?
Yes,
Yes, Mwalimu.
All right, that's fine. Now let's go. Put your hand down and mute your microphone, please. Let's go and talk about another duty. So as I'm talking about these duties, please make sure you you take note, so that if you have a question, you will ask as we proceed. If you have a question, you just ask as we proceed. But make sure you take your notes or note your points, and then if there's a question, you can ask. So we have talked about the duty to pay, and there are three things to be paid. There are three things that are supposed to be paid. The next thing is the duty to collect, which I have already talked. I have talked about the duty to collect that I've talked about. All right. So the next thing, that is point E, which she has already mentioned. So we'll proceed from this one, E. So Sharon, read from E. That is the duty to account.
Okay. Within 6 months from the date of the grant, to produce to the court a full and accurate inventory of the assets and liabilities of the deceased, and a full and accurate account of all dealings therewith up to the date of the account. F, subject to Section 55, to distribute or retain on trust, as the case may require, all assets remaining after payment of expenses and debts as provided by the preceding paragraphs of this section, and the income therefrom, according to the respective beneficial interest therein under the will or in intestacy, as the case may be. G, within 6 months from the date of confirmation of the grant, or such longer period as the courts may allow, to complete the administration of the estate in respect of all matters other than the continuing trusts. Kindly scroll up.
Sorry.
Where was that? A full inventory and liabilities of the deceased, and a full and accurate accounting of all dealings therewith up to the date of the full account. I think my miss there. It was G. Yeah. Okay, let me just repeat that. Within 6 months from the date of confirmation of the grant, or such longer period as the courts may allow, to complete the administration of the estate in respect of all matters other than continuing trusts, and to produce to court a full and accurate account of the completed administration. H, to produce to the court, if required by the court, either of its own motion or on the application of any interested party in the estate, a full and accurate inventory of the assets and liabilities of the deceased, and a full and accurate account of all dealings therewith up to the date of the account. I, to complete the administration of the estate in respect of all matters other than the continuing trust, and if required by the court. Jackton, kindly scroll up.
Yes, proceed.
Scroll up. I, to complete the administration of the estate in respect of all matters other than continuing trust, and if required by the court, either of its own motion or on application of any interested party in the estate, to produce to the court a full and accurate account of the completed administration.
Perfect. Thank you. Thank you for that reading. So let's just note down the points. So we've talked about the duty to pay, done. Collection, we've done that. The duty to account, you have to prepare accounts. When it comes to duties to account, then this is preparation of accounts. That is the estate accounts. You have to prepare the accounts. Okay. So show us, how did you use this money? You have the duty to do that, to show an account. And then after that, you have the duty to distribute, the duty to distribute the estate. That is your duty. The estate must be distributed to those that are entitled to that specific estate. So the beneficiaries, they need to have the estate distributed. So it is your duty as the personal representative to proceed and distribute that estate. You don't keep them waiting for a long time. And then, of course, we have the duty to confirm the grant. Remember that the grant must be confirmed within 6 months. Within 6 months after the lapse of the first 6 months. Okay, so you have the duty to confirm the grant. And we talked about the question of revocation in the last class, and we say anytime you fail to confirm the grant, that grant shall be revoked. Anytime you fail to confirm the grant shall be revoked. So you have the duty to confirm the grant within 1 year from the date that grant was issued. Okay, and then you have the duty to produce to court a complete report on how the administration was conducted. And then lastly, of course, is the duty to complete. You have the duty to complete administer. You can't administer forever. You can't be doing that for over and over and over and over again. Are you together? So you have to complete the process of succession within some period of time. Normally, you're given 1 year, but it depends. The court can always extend it if the court feels like you have not something has happened. Maybe there's some dispute and everything else. Then that time can be extended. But you need to complete it. Don't go distributing 1 year, 2 years, you're still distributing. No, you have the duty to complete it within a specified period of time. So those things can also be changed to become the powers. Questions? All right, no questions. So somebody read for us the offenses. Now remember, guys, before we get to offenses, remember one thing, a few things. Okay, you will get a question just like the one in the 20 series, that is, I think 2022, where you're being told that somebody died and left behind 2 children. The children were taken in by the aunt, who then became the administrator. The aunt proceeded to, take the grant and then squander the entire amount of money. So anytime an administrator or an executor of the will has done something, that becomes an offense. It becomes an offense. So the first thing you need to identify is who is the personal representative. If you're given a question and you're being told James Maina, this person or this person or this person, ask yourself, who is this person? Are they beneficiaries? Yes. Are they personal representatives? Yes. So you need to identify first the people that have been mentioned in the question. Who are they? This person could be the lawyer. This one could be the beneficiary, the child or the wife, or this one could be the personal representative. Any person that takes out a grant is a personal representative, or any person that is named in the will is a personal representative. Are we together? So they have the duties and they have the power. So you look at how they diligently delivered on their powers and their duties. If that is not the case, then they have committed an offense. Now let's look at the offenses of personal representatives. There's so many. Okay, so the first thing you need to understand is that a breach of the duties, all the duties we have discussed, failure to pay, failure to collect, failure to administer, failure to confirm, any breach of your power or any breach of your duty is an offense of a personal representative, in addition to the ones that we're going to discuss right now. Are you together? All right, so section 95, the offenses of personal representatives. Somebody read, somebody else.
Offenses of personal representative. 1. Any personal representative who, as regards the estate in respect of which representation has been granted to him, A. Willfully or recklessly neglects to get in any asset forming part of the estate, misapplies any such assets, or subjects any such asset to loss or damage, or B. Willfully fails to produce to the court any such inventory or account as is required by the provisions of paragraph E and G of section 83, or C. Willfully or recklessly produce any such inventory or account which is false in any material particular, or kindly scroll down. D. Knowing or having reason to believe that the estate will prove to be insolvent, continues to administer it without petitioning for administration thereof in bankruptcy, shall be guilty of
Proceed. Just proceed. Sorry.
Shall be guilty of an offence and shall be liable to a fine not exceeding 10,000 shillings, or to imprisonment for a term not exceeding 1 year, or to both such fine and imprisonment. Over to you, Jackton.
All right. Thank you. Now, let's talk about the offenses. And I've said the first way of noting an offense is through understanding the duties and powers. So we have said any breach or any violation of duties and powers is actually an offense. That is actually an offense. So that is where you start from. Now, in addition to that, we also have some offenses that have been defined. Number one is you refuse to get in or to collect. Getting in simply means you collect. You collect the assets and you bring them into the estate. So if you failed or you refuse negligently or recklessly to do that, then that becomes your offense as a personal representative, either as an executor or as an administrator of that estate. That is one. Number two, if you misapply the asset, what is this thing you're calling misapplication of the asset? It's very simple. The asset was supposed to be meant was meant for a beneficiary. For instance, it was supposed to go towards their school fees or whatever. You have decided to squander that asset or to do whatever was not said that asset is supposed to do. So in that instance, you have misapplied the asset. You've used it for a reason that was not ratified under the will or under the grant. That is misapplication. You're doing your own things. All right. So if you misapply the assets, then that becomes an offense under the law of Succession Act. The next one is when you fail to produce the records to court. We said that you have the duty to produce an account and a report to court indicating how that specific administration was conducted. Okay. Now, if you fail to do that, that is an offense. If you fail to do that, that is an offense. Are we together? So the next one is the question to do with willful or reckless. You willfully or recklessly produce a false inventory or a false report. You know very well that you are lying about this, that is not accurate, but you willfully bring it. So if you lie, of course, to court, you know the consequence of that. Any lie to court is a serious crime. And of course, you'll be guilty and you shall go in for some time. Okay. And then this other one is very important in terms of what you call insolvency or bankruptcy. So if you realize that the estate of the deceased person is insolvent and you fail to apply for or to petition for bankruptcy, then that is an offense. So how will you know that the estate of the deceased person is insolvent? Somebody tell me. How will you know that the estate of the deceased person is insolvent, is insolvent, or is approaching, or is bankrupt, is approaching bankruptcy? Wakia Garawat?
When you realize that the liabilities are more than the assets.
Yes, that is the
One.
law. That is the law. So remember, when you're applying for the grant, okay, remember, when you apply for the grant, the petition will include something, which is the list of assets and the list of liabilities, the schedule of assets and the schedule of liabilities. Now, if you include that in your petition, the assumption is you already know, okay, that this estate is insolvent, or this estate is bankrupt or heading towards bankruptcy. If that is the case, then you need to petition for bankruptcy. So if you proceed and distribute the assets, you know very well that this estate is going to be bankrupt because they have more liabilities than assets, and you just keep distributing to the estate, to the beneficiaries. It means you are committing a fraud. And who are you defrauding? You are defrauding the creditors, and that will become an offense. You're defrauding the creditors, and that is an offense. Okay? All right. So those are the offenses of personal representative. These are the offenses of personal representative. Offenses of personal representatives. Any question?
No question, sir.
All right. Going once. Any question? Something that is not clear?
Yes. Not on the offenses, but on their duties. There was that part G, if I correctly remember.
If you can't remember, you can't have a question on it.
No, I'm saying I'm remembering that point G, where it speaks about 6 months. Like they have to submit. Is it a must for the personal representative to submit to the court after 6 months of what they have done?
It doesn't have to be 6 months. Listen,
Yes.
listen. Let me explain. Now you know that this specific act was enacted in 1981. So
Yes.
the aspirations, the spirit of the act is that you're supposed to get done with this thing in 1 year. Distribution imalizane 1 year, umemaliza. But you and I know very well, okay, that
Yes.
this will sometimes there are estates of the deceased person that can take 20 years, even 30 years. They're still distributing. They still dispute after dispute after dispute after dispute. Okay, so that means that this 6 months period sometimes will not be
Possible.
will not be possible. Are you together?
Yes.
All right. Any other question? All right, so we will look at questions. We look at questions regarding personal representatives. We'll compile them, and then we'll share them, and then we'll go through them together, and then we'll see whether we understand. All right, let us go and talk about something. Now I'm opening the floor. Anybody that had a question, ask now as I bring up my estate accounts.
Well, a question. I'm trying to raise my hand and it's not getting raised.
Why is that not getting raised?
I don't know what is happening on this end. I don't know whether it's raised on that other end. It's not showing.
Oh, your device, my friend, device. Your gadget. Anyway, please ask.
Yes, yes. I wanted to ask, we've discussed misapplication, and there is this other term that I've been meeting, misappropriation. So could you please just shed some light on the two?
Misappropriation is misappropriate. Appropriating is spending. Misappropriating is you're misusing. So when you have the asset of the deceased person and you misuse it, that is misappropriation. Okay. So
Yes, yes.
misappropriation is, appropriation is simply the distribution or like expending. When you're expending something, that is appropriation. You've seen even in the county government appropriation bills, which is a bill that is supposed to distribute the resources within the counties and among the counties. So if you have the opposite of that, that is misappropriation. It means you're using it for a reason that is not proper. You're misusing it. Are you together?
Yes. Then what is the difference between it and misapplication?
Same thing, my friend. Kizungu too. It is the same thing. It means the same thing. Misapplication or misappropriation.
Okay.
One and the same thing. I'm trying to retrieve something. Another question? As I bring my estate accounts. Why is that coming up? Yes, Gertrude.
When it comes to the powers of the executor that arise are derived from the will, so they can act immediately. The will immediately the testator dies. So
yes,
Section 55 talks about no distribution of capital assets. So they can do anything apart from distributing capital assets.
Yeah, capital assets are not supposed to be distributed before the grant is confirmed, and capital assets simply means land and buildings. But everything else they can do.
Okay. Thank you.
All right. My screen should be up now. My screen should be up. So let me try and project it again. No. You guys don't have questions. But I hope when you retire to sit down and discuss with yourself in terms of how much you've garnered or how much you understand probate, you will be able to understand or note down the questions, note down the areas that you're not strong in, and then we can go through them as we do the revision. Okay. Okay. I hope so. And I'm hoping that my screen should be up anytime right now. It is up. I hope so. So
yes, it is.
Estate accounts is the easiest accounting that you will encounter. I know most of you ended up doing law because hesabu ilikataa. Hesabu ilikataa kabisa. How do you know that hesabu ilikataa? Kama hukuwahi enda any maths contest, jua tu wewe ni mtu wa CRE. Jua tu maths ilipita nje. Just look at your life. This is what the pastor will be saying, that I don't want you to answer, but just look deep within you. Do you think you ever went for a maths contest? If you didn't, you are too ilipita huko nje. So this specific accounting is for those that don't need a lot of maths. Math is hard for everybody. So it's a very simple accounting. It's a very, very simple accounting. And don't confuse it with financial accounts. Okay. So there are a few things you need to understand in estate accounts. The first one is a memorandum. The second is a schedule of assets. The next one is a schedule of liabilities, the cash account, the distribution account, and then the aspect of actual distribution. Okay, the aspect of actual distribution. So those are the only things you need to understand in terms of estate accounts. So let's start from the first one, which is called the memorandum. What is a memorandum? What is a memorandum? What is a memorandum? What is a memorandum? All right, so a memorandum is just a narration or a summary of key events, okay? Key events following the death of the deceased person. That is what a memorandum is. So what is supposed to go into a memorandum? Number one, when the deceased person died, the first one. Number two, did they die tested or intestate? Number three, the beneficiaries that they left behind. Number four, any steps that have been taken by the beneficiaries regarding either the limited grants or the grants, or could be a case that has been filed in court. That is what goes into a memorandum. That is exactly what goes into a memorandum. And please do not confuse it. It is a very simple thing. Do not confuse it. It's a very, very simple thing. All right. So in our case, you'll be given a question. You'll be given a question, an entire storyline, and then from that storyline, you'll be told to prepare the memorandum. Rarely will they. It's a long time. They have never set a memorandum before, and never say never. This could be the first time they set it. So when they do set it, please make sure that you understand it. So I've said it is just a summary of the key events in the life of the deceased person after death. So when did they die? Did they die tested or intestate? Who did they leave behind? Who is their spouse? And who is that? The children. Is there any application that has been made, or is there any limited grant that has been issued? That is what you need to understand in as far as the particulars, the memorandum is concerned. Okay, so number one, James died in the estate of the intestate on the 23rd June of 2022. He was survived by one spouse, that is Mary Jane, and then he left behind 3 children, Joe, John, and let's just say 2 of them. Okay, and then something else that happened is that there's already an application for limited grant agricultural gender that was made on the 24th May can't be 24th May, 24th of October. Okay. Uh, 24th of October, 2022, and then a limited grant has been issued. Limited grant agricultural gender has been issued. It could be as long as anything, just the summary of what the key aspects of that estate that will go into the memorandum. Okay. The next one is what we call the schedule of assets. No. Questions? Any question? No question. So let's go to the second document, which is what you're calling the schedule of assets. A very simple thing, very, very, very simple, extremely simple. What do you need to have in the schedule of assets? Very simple. Just give us the assets. Go to the question and give us the assets. So what assets did this person leave behind? The item number, the particulars of the assets, and the remarks. Now, remarks are usually the value of that property. So there's a house in Karen. Which is resting on LR number 123/3. The house is valued at 11 million. Okay, that is the first asset. There is land in Kajiado, Ngong 7658. The land is valued at 5 million. There's a Mercedes-Benz C250 KCX 237G, the car is valued at 5 million. Okay, you could find land, shares at KCB, money in the bank, all those are assets. Okay, so just go to the question and give us the list of assets. Okay, and give us the value if you've been given the value. If the value is not given, don't fix a false value, just leave it open. Is that hard? Can anybody do that?
That can be done, Mwalimu.
Okay, that is the schedule of assets. Now let's go to the third one, which is the schedule of liabilities. Again, a very simple document. Just give us the schedule of liabilities. You can be told to prepare the schedule of liabilities. You need to understand what liabilities are. So just go through and give us which liabilities do we have. The first one is a debt from Michael. So this estate or the deceased person owed Michael 100,000 Kenya shillings. So that is a debt from Michael. Number two, there's a loan that was advanced by KCB. That is a loan of 2 million shillings. Okay. There's a mortgage. There's a car mortgage that is being paid by the estate, that was being paid by the deceased person, which is currently at 5 million shillings. Okay. 5 million shillings. Are you together? So that is the schedule of liabilities. So again, assets, liabilities, simple. Just give us what the assets are and their values. The liabilities are and the value of that liability. Are we on the same page now?
Yes, we are.
All right. That is proper. The next one is what we are calling the cash account. Very simple. The debit and the credit side. The debit and the credit side. Very, very simple. Just the debit and the credit side, two sides. So all the money, all the income, one side, the expenses, the other side. Okay, that is all. This is not about assets. This is just about money, cash. Okay, the cash that comes out and comes in. So every money that comes in, of course, the debit side, and every money that goes out is the credit side. Simple. Expenses and income. So there is receipt. That is the particulars of receipt, and there's the particulars of payment. So what expenses did you pay? How did the money leave the estate? Okay. So we are going to have the first one. There's rent that has been received from the current property. Rent is being received, which is 100,000. So you prepare this thing as of this date. Okay, as of this date. Okay, let's say the rent in this question is 2023. Sorry, 2023. Okay, so as of that date, you receive rent. So sometimes you can prepare it for a year, for 6 months, for a quarter. So you just give us within this quarter or within this year, how much money have you received? Okay, now we've received a rent from Karen on this date, this much. Okay, we have received some dividends that were paid from Safaricom, that much. We have received pension. If this person was a teacher and he was paid his pension, the pension will come into the cash account, which is that much. Okay. On the other side, we now also have the payments that we have made. Okay, we have paid the debt from the debt that was owed to Michael, to Melipa, the 100,000. Also, we have paid the funeral expenses. Okay, so all the things you paid, because this is just an example. This is not an actual question, but these are just an example. So what example are we saying? We have paid, we have received. We have received this much and we have paid out this much. So that's the cash account, which now indicates how cash is moving. Are we together up to that point? Are we together, guys?
Yes, we are.
All right, so let's go up. Memorandum, we are together in terms of the narration of the estate. The deceased person died at this time, he died at this date, he left behind this person and the children, this application has been done and all that. The assets, that is the schedule of assets. just the list of assets and their value, the schedules of liabilities, which is the liabilities and the value, and then the cash account, which I've just indicated, that is how much money has been received versus how much money has been spent. Okay.
Yes.
All right. All right. So let us go and talk about that distribution account. Guys, when did we say you prepare the distribution account? Yes, Elias?
When you are about to distribute the...
That is not an instance where we prepare a distribution account. When do we prepare the distribution account? Yes, Cherono?
Once the temporary grant has been given during the 6 months.
Alingo, Penina?
Distribution account is made after the estate of the deceased person has been.
So if your answer is after or before or during, that is not the answer I'm looking for.
When you are issued with a certificate.
No. Abdisalan?
Yeah.
I can't hear you. Abdisalan, I can't hear you. Somebody else? When is this thing a requirement? When is it necessary to have? Yes, Gertrude?
Where the deceased died intestate.
Thank you very much. Where the deceased person died intestate. And the reason is very simple. What is the reason? When the deceased person, if the deceased person has died testate, it means there is a will. The will shall have the distribution itself. The will shall be saying, this person take this person take this person take this. So the distribution will be in the will, and therefore we don't need to prepare another distribution account unless the will has been challenged successfully. Now, so it is only under intestacy where we shall prepare the distribution account. Now, for us to have the distribution account, okay, we first need to understand how much money do we have? How much money do we have? How much do we have which is available for distribution? For you to know, or for you to come up with a distribution account, you must first understand how much money is available for distribution. Okay? How much money is available for distribution. So how will you know that? You have to calculate the net estate. Net estate is the entire estate minus the liabilities. Okay? The entire estate minus liabilities, because the only thing you can distribute in the estate of the deceased person is the net estate. So you have to ask yourself, how much do we have in terms of liabilities? This. How much do we have in terms of assets? This. Then therefore, what is the net estate? The assets minus the liabilities. So once we minus the liabilities, then now we have the net estate, which is the value that is available for distribution. The only thing you can distribute is the net. If you can't get the net, then you can't distribute anything. Okay? So in our question, we are going to have our assets and our liabilities. Okay? We are going to have our assets on one side, liabilities on the other side. The total of assets is 40 million. The total of liabilities is 5.1 million. So we get the net estate. How do you get the net estate? By just adding the assets minus the total liabilities. So our 40,000 minus 5.1 will give us 34,900,000. So that is our net. That is our net estate. That is our net estate. So the value that is available for distribution is 34,900,000. 34 million, sorry, 34,900,000. Guys, are we together?
Yes, sir.
Yes, Mwalimu.
All right. So let us prepare the schedule of distribution. So when do we prepare the schedule of distribution? Okay. The schedule of distribution is prepared as per, okay, it is prepared as per the rules of intestacy, section 35 all the way to section 40. Now, in that instance, remember something. What do you remember? Remember the law. What law? The law as to, okay, the law as to, the rules of intestacy. If the deceased person left behind a spouse only, what is supposed to happen? All right. All right, so let me explain. So, guys, before you prepare the schedule of distribution, you just need to understand a very simple concept, which is the rules of intestacy. The rules of intestacy are supposed to provide for the distribution. So we said that if the deceased person left behind a spouse and a child, then the spouse will be entitled to all the personal and household effects. Okay, so in our question, this example, guys, this example is only given, the one that you're seeing on your screen is made on the assumption that everything is about money. This person left behind just money. So we've sold everything. But there are some examples where you will be distributing actual assets. Somebody will take land and all that. Okay, so what is the rule here? When the person left behind a spouse and a child, the spouse will be entitled to at least, not even at least, at most, all the personal and household effects of the deceased person, they go to the spouse. So if you are preparing this, let me show you just a quick example. Let me show you a very quick example. Let me try and type. So assuming here, let me remove this. Let me remove this. I don't know whether I can draw on this. All right, so let's draw something here. Okay. All right, so let's assume that this person left behind a spouse, Jane. Okay, so in this instance, what will Jane have? Okay, so Jane will have everything. Okay, which is the personal and household effects of the deceased person. So you go to the question and ask yourself, what are the personal and household effects? So for instance, there are jewelries. Okay, could be there was maybe shirts. And we said in this class that malipo is just here. You know, there's a word that people say that malipo ni hapa hapa duniani. You know, and some of you are prone to be buying your loved ones, more so your male loved ones, just socks on their birthday. The law says if they die, ni wewe utabaki na hizo socks. So if you've been buying that person socks every birthday, 20 pairs of socks, ni wewe utabaki nazo, utavaa mpaka kwa kichwa. So please buy someone something that you will be proud having when the Lord calls them home. You know, hizo vitu zote ulibayia mtu wako, all those things you will have them. So malipo ni hapa hapa tu, endelea kununua socks. Your distribution account will be looking like this: socks and all those things that I won't mention. Okay, so everything, the personal and household effects, okay, including the seats, everything, laptop, a phone, all those. Okay, so let's add a phone. Yeah, so if you don't want your partner to see your phone, unasema malipo ni hapa hapa tu. Ukikufa pap, hiyo simu ni yake mpaka password. So fikiria mara mbili. So all those things, the personal and the household effects, they'll go to Jane. They all belong to Jane because Jane is a surviving spouse, and Jane will be getting all the personal and household effects. And then if there are other assets, then Jane will have what we call a life interest. So the next bit will be a life interest in, actually, not that. So we're going to have life interest in, number one, the car. Number two, the house. Yeah, let's leave it at that point. So what I'm saying is that is when you leave behind a spouse and a child. Okay, you get all the personal household effects. Actually, you could even indicate absolutely. Absolutely. You will have all those things, and then you'll have a life interest in the remaining net intestate estate. Okay, so that is the rule. That is how you prepare that schedule of distribution. Okay, and then of course, you know, the remaining children will be benefiting as per the power of appointment. All right, so if you leave behind just a spouse only, okay, what will be the spouse entitled to? For instance, in our case, the spouse, the amount, mute your microphone, please. The amount that is available for distribution is 34,900,000. Okay, that is the amount that is available for distribution. Are we together? Now, if you leave behind just your spouse alone, your spouse will take at least 10,000 or 20% of the estate, whichever is higher. So 20% of that estate will go to your surviving spouse. So you'll be coming and saying, Jane will get 20% of 34,900,000, and then life interest in the balance. Okay, the life interest in the balance. That is how you deal with that. The next instance is, what if the person left behind just children? Then everything will be distributed equally among the children. Are we together?
Yes, we
Yes,
are.
Mwalimu.
Yes, we are.
Yeah, so you go to the rules of distribution. That is what I'm saying. You go to the rules of distribution. So assuming that we have 3 children that were left behind in this instance, what are the children supposed to be getting? Each child will be getting 34,900,000 divided by 3, each of them. That is the schedule of distribution. Any question? Put up your hand, please. Mute your microphone and put your hand up. Mute your microphone or I'll throw you out, guys. Stop. Let me throw this one out. Okay. Yes, Nyangao?
And when we're discussing the duty of the personal representative, where we have pay out of the estate, the expenses of administration. Now, in preparation of this distribution account, and when we have come up with the value of the net estate, where do we factor in the money like legal fees and whatnot?
What do you think? What are those? What are they?
Expenses.
And what are they now if they're expenses? Where do we factor them?
Okay, I've understood. I'll factor them in the cash account.
What do they, this is different from cash accounts. This is just distribution alone. You don't. Nobody will ask you to draft all of them at once. You can be told to prepare the cash account alone, schedule of assets or liabilities alone, memorandum alone, or the distribution account alone. So we are talking about distribution here. Where do you factor them?
If we're asked to draft only the distribution account, personally, I'd put it under liabilities. I could be wrong. I don't.
We have two things. We have assets and liabilities. Where do they fall? Quickly answer that question.
I'll put them under liabilities.
Yeah, I guess you answered then. We have assets and liabilities. Anything that is not an asset is a liability. Anything that leaves the estate, anything you're supposed to pay, any expense is a liability. That is accounting, simple accounting, basic accounting. So anything that leaves your pocket, liability. Bills, expenses, legal fees, all those are liabilities. So you pay them first. Once you pay them first, whatever remains is what you distribute. So you go there, particulars of liabilities. Number 3, we are going to have legal fees, funeral expenses, all those things are liabilities. You pay all of them. Yenye itakuwa imebaki, you remove, you distribute. And we say that if you realize that your liabilities are more than your asset, then that estate is insolvent, and therefore you cannot distribute anything. Right together. So that is exactly how you're supposed to prepare that specific account. So anything that is not an asset is a liability. Alphonse?
Yes, I have 2 quick questions. So the first one, when preparing the memorandum, must you like follow the order which you gave? You start from when the deceased died, and then you follow it in that order that you gave, or can you just like start from any of them? Then the second
No,
question.
why are you starting from any of them?
Because
why are you starting from any of them?
Okay, so that is answered. Then the second one, when you are told to prepare the distribution account, are you supposed to prepare like even the schedule of distribution, or you'll be requested to prepare the schedule of distribution specifically as its own independent item?
So the distribution account should end here. Let me highlight all in yellow. So that is the distribution account. The schedule of distribution is different now.
Okay, that is clear. Thank you.
So the result of a distribution account is this. Let me undo and show you. The result of a distribution account is this that I've highlighted in yellow. The value available for distribution. That is what you need to give us in your distribution account. Okay, that is the value that is available for distribution. All right, so You get a question asking you, prepare the memorandum, that is what it is. A question asking you the schedule of assets, that is what it is. The question asking you to prepare the schedule of liabilities, that is what it is. The cash account, that is what it is. The distribution account, that is what it is. Schedule of distribution, that is what it is. However, for schedule of distribution, you must understand the rules of intestacy. When this person is left, what do they get? When this person is left, what do they get? Guys, are we together?
Yes, sir.
Yes, we are together.
All right. Then that is the end of this class. I will stop sharing, and that is the end of probate. From next week, we shall be doing past papers only, and of course, explaining as many concepts as possible, so that you understand where we are coming from and where we are ending. We've had a long session, a total of 11 classes to explain entire probate. Of course, we move very slowly because of probate is something I do in one sitting, entire probate, but we've done long and long so that you can understand. So please jog for the next class, which is now the past papers, starting from the most recent past paper, which is the 2024 April paper. So we will look at it, what has been said there, and then go to the next paper. As we do that, we'll also be revising the concepts we've discussed in class. Things like we'll be meeting a lot of things there. So we'll be explaining them and you will be understanding. We will be doing some drafting. That paper has no distribution account or any exit account, but it has the drafting of a will. So we will be drafting the will in that class. But please, before you come to that class to draft the will, please revise on drafting a will so that when you start drafting it, it is a revision to your ears. Okay, that is what I'm saying. So please take some time and go through your personal reading, and then everything shall be okay. Tuko sawa?
Yes, tuko sawa.
All right. It is 8 minutes to time. I want to leave you early so that you